you always find that an act or a piece of legislation to a reasonable person looks fine. You read it and everything else. It's when you try to apply it that you always get screwed over. You always find out that somewhere there's a loophole. And, I really respect Cashin and Young for even bringing this forward to what they did. But, when you're going against an industrial strength lawyer and the assets, and I mean like this, that Crombie can bring to this, you're screwed. Like, I don't believe for a second that they're going to go with an audit. I think that the lawyers won again. However, that said, I am really impressed with the chair of this committee. He did a good job all the way through and gave both sides a really fair hearings. We'll see what happens, but I'm not hopeful. So I'm going to turn it this way. Actually, maybe we should give people privacy by doing this. Okay, so we got this over here. Actually, they're probably not ready yet.
Yes.
Okay, here.
Okay. Well, Mr. Cashin.
Thank you very much. Number one, I'd just like to thank the committee for giving us this time. We've heard some great positions from Mr. Siegel, and he's driving home the words legal jargon, things like absurd laws and thresholds and all these kind of very technical legal terms that I got to admit are a little bit over my head. But I believe this whole process has been set up to protect the democracy and let us, an ordinary citizen, come in and talk to you about these issues. Mr. Siegel keeps trying to push back and say it's the responsibility of the candidate to prove that the candidate did not report something, which is the defendant. We cannot prove something that's not declared, which we will get into.
More accessible.
We can't control disclosure from any candidate. All we can do is look at it, do somewhat of a forensic accounting and see if the trail continues and you can find a way through your accounts, how that all works. The bottom line is this is done to create a level and playing field for anybody who wants to run for municipal politics. The real question is who paid for the signs and stakes? We've heard that all of a sudden, just because Mrs. Crombie was a candidate in a federal election, she all of a sudden owns those campaign assets, which I would almost agree with, except for the fact that she still has a 2011 federal campaign still open while she was in this campaign. So until that campaign is officially closed, it is my belief that the association or the party owns that until the close of a campaign. We've also heard that she didn't use the 2011 campaign signs because they had a re-elect of it. But if you go to our submissions on the Whitehorn polling station, which was the 2011, there is no re-elect on her sign, on the large signs. And on the small signs, Mr. Siegel admitted they never even entered that into inventory. They just started blending all of these different assets to what they believe was good enough. The Municipal Election Act isn't set up so that it's the determination of the candidate to make a determination that's what's good enough. It is the responsibility of the candidate to report the exact expenses that are spent on a campaign so that everyone has a fair chance. We've noticed numerous times, and these accusations that I'm making, i.e. the post office, well, if they're so wild, then why was it admitted to that it was, but it was folded into another expense. I'm not saying that it's reported incorrectly. All we're saying is we have difficulty connecting the dots and adding up the numbers. And the fact that we believe if you included everything into the campaign that should be there, it's over the spending limit. And the bottom line is if every federal and provincial candidate all of a sudden became the owner of their assets without any financial transaction back to the party, then provincial and federal candidates would have a superb advantage in municipal politics, and then municipal politics would no longer be siloed by the act. They would be bombarded by all these partisan politics coming in. A check has to be written for those assets. It doesn't happen by osmosis. It's not up to Mr. Delaney to create a fair market value for his own stakes. He can sell them for 10 cents, that's correct. But they do have to be reported at a fair market value. What we've given you in the reports is there's no proof that any of these assets were paid for by Mrs. Crombie to the provincial campaign. There's nowhere in those that there's a trail that that's been paid for. And again, do we want an audit? An audit's only needed to bring clarity and to be transparent in this whole process. Mrs. Crombie said that the vote Crombie has been used for years in the campaign, if I'm correct. However, that URL was registered 2 months before she registered for, the domain name was registered 2 months before she registered as a candidate for the campaign. So that's you can find easily on the internet. So I find it difficult actually finding where the credibility of what's real and what's not real in the statements. Access to elections is key to be fair. Where it's reported, absolutely, there's a certain amount of creative license with that. But again, it still has to add up. You have to be able to follow the trail of money. You have to be able to reconcile it. Trying to decide or let a candidate decide what's in the campaign or what's outside. Sorry? What's inside and what's outside the campaign is not the candidate's privilege. The Act states that you can't spend anything before you register. You can't spend it after. The costs for these things do have to be reported. Really, just to summarize, we believe that what we brought you is enough evidence, it's credible, it's objective, it's nothing relying on us. We've brought other people to the table to prove what we believe to be an issue in the reporting of the campaign finances. Thank you very much for your time. Siva?
This is a legal process. I'm sorry I'm a lawyer, and I have to use legal terminology, but the courts have said this is the test that you have to apply. Mr. Cashin, I actually have some sympathy for him if he doesn't get all this stuff. Truly, I've done my best to put it in lay terms. The basic lay terminology that I kept coming to, and they told me in law school, you tell them what you're going to tell them, then you tell them, then you tell them what you told them. Drive the point home 3 times. What the courts simply say is there has to be an objective belief, there has to be compelling information, there has to be credible information, and a reasonable probability of a breach. Let's look very quickly at the wording that Mr. Cashin uses throughout his submission. Paragraph 7. We sincerely believe, as opposed to what we base that upon. Section 37, paragraph 37. May have occurred. Paragraph 45, we want an audit to ascertain whether something happened. An audit isn't something you simply assume happens. You have to establish a particular reason for the audit, not his concerns about having been treated unfairly, or not. I would argue that it's been perfectly fair. Mr. Cashin will probably do his dying breath say it wasn't. That's not the question. What I think, or what he thinks. The question is whether it conforms to the rules that were set up by the province. He has to identify a breach of those rules, and he's fallen far short. What he has done is he said, we want you to look into it. We want to have it to find out. There's no way of knowing. There's no clear picture. We want to ensure no breaches. Should it be discovered? It is not known. These are all phrases used, peppered throughout his submission and his oral comments. That's not the question before you. Returning back to the specifics here, on the campaign signs issue and the notion of the party, let's make it very clear. The Liberal Party of Canada has filed its return. The Writing Association has no obligation to file a campaign return. It is Mrs. Crombie as an individual who has an extension, and I've addressed the question of her status as candidate and whether or not it makes any sense to say that she can't contribute her own property. It's simply bizarre. Mr. Cashin says that Siegel admitted the signs weren't brought into inventory. To the contrary, I said they were brought into inventory at a potentially inflated price of $5.99, the cost of a big sign, whether it was big or small, for a grand total of 1,000 signs, big and small. If anything, the cost is overestimated. He says that the URL, vote Crombie, was paid for 2 months before the campaign. Well, that would be before the decision was made to run, from anything you've heard. But over and above that, it was a renewal of a pre-existing URL. You have to pay again to renew an URL from time to time. The presumption he makes is that the candidate's not entitled to estimate what costs you assign to the Delaney stakes or to the signs. That's exactly what you have to do. And the law permits that, and that's why there's the initial auditor to assess some level of reasonableness and sign off on that. He has to, if he wants you to give him an audit, provide real evidence as to why the values placed by estimate are completely out of whack, and he has not done that. Plain and simple, Mr. Cashin, in my submission, is engaged in an exercise of speculation, guessing, and wishful thinking in the hopes that he can land a punch on the duly elected councillor. In my submission, the whole point of a compliance audit committee process is to ensure that the charges or complaints that are brought pass through a filter of legitimacy provided by the 5 of you. And it's not simply a matter of random attack. If you can take a look to my submissions, I don't have time on the 5 minutes to repeat it. There is a passage from court decisions about the whole point of this being to insulate candidates from random drive-by financial attacks. There's no basis for an audit. Thank you.
Now we're going to consider immediately going to remove the camera for discussion with our legal counsel. So can I have a motion from my member to move the camera, please? One second, please. I'm going to read the motion now. Whereas the Municipal Act 2001, as amended, the Act requires a resolution to be passed prior to closing part of a meeting to the public. And whereas the Act requires that the resolution state the act of holding of the closed meeting and the general nature of the matter to be considered at closed meeting. Now therefore be it resolved that a portion of the election campaign finance committee meeting held on February 7, 2012 shall be closed to the public to deal with the following matter. Pursuant to Municipal Act Section 239(2), Section F, advised that is subject to solicitor-client privilege, including communication necessary for that purpose. Therefore, we're going to move in camera now. It's almost 11 o'clock. A lot of submissions are given from both parties, conclusions and everything. We need good, reasonable time. So we'll take 20 minutes. If we need more time, Laura will come and advise you if we need more time. Hang on. I will come back. Thank you very much.
Are you retiring or are we?
We going in the
You have
camera,
private.
you guys have 10 minutes.
The Toronto Committee
Almost
throws-
11 o'clock.
The Toronto Committee throws us in.
11:20 will come back, or you will hear from Laura if we need more time.
Okay, turning the high definition. Okay, and I'm just gonna put my prediction. They're gonna side with the lawyer.
Meeting will now reconvene. Will the member please bring forward a motion to defer the decision?
I motion to defer.
Wow,
I second it.
wow.
In favor, can I have a vote? Not in favor? No. Not in favor? Not in favor. 3 against 2. But mine was also not in favor, but because I seconded technically, so mine is not in favor, also 4 against 1. Can I have a motion from the floor to accept the application and request to appoint an auditor? I'm making a motion to accept the application for compliance audit and appoint an auditor. Can I have a second for that? No second? We're not. So how can we motion carry without a second? Can we? So, are you in favor? Are you in favor? No. I'm in favor because I made the motion. Okay. So, 4-1. Can we have a motion to reject the application?
So moved.
This guy's are good.
Andy? Mr. John? I'm not in favor. In favor. 4 against 1. Therefore, results are in front of you. The application has been rejected based on no reason. You want to give this?
The application has been for compliance audit, has been rejected by the Election Finance Campaign Finance Committee on the grounds that there has not been any sufficient credible evidence that has been presented to the committee which is compelling and credible enough to raise in our mind a reasonable probability of any breach of the statutes. Consequently, we do not support the application and it's rejected.
The decision of the committee may be appealed by either the applicant or the respondent to the Ontario Provincial Court of Justice within 15 days of the date of the committee decision. The Election Campaign Finance Committee has considered the application for compliance audit submitted by Mark Cushion and Cecil Young. Following examination of this application, the committee has decided to absorb the meeting myself. The committee will take no further action with regard to this application. On behalf of the members of the Election Finance Committee, I wish to thank the respective applicants and respondent for your participation. Each of you will receive a formal notice of committee decision. Thank you very much. Good night.